People will look for reasons to come after your client's earnest money.
Absolutely. And it's some of the most nitpicky stuff. I had an issue. Okay, so got my license back in 2005, got my broker's license in 2009. So I've been in the business for a while. I know you've been in the business for a while, so we're constantly
Although
learning.
I don't look like it. I look a little younger.
You're young. It's no matter what, we all know this. We know that there's something to be learned on every transaction. Right. Now, I ate some humble pie. I had a conference call with a cooperating broker. And what I mean by cooperating broker is a broker from another company. And they were trying to make the argument that my clients had lost their earnest money. Not my clients, one of my agents'
Your
clients.
agent's clients, right.
We had a scenario where one of our agents made an offer on one of his agent's properties. Okay. And our agent canceled the contract prior to the due diligence deadline. And naturally, I would just think, well, great. We follow the language of the contract, which states that the earnest money shall be delivered back to the buyer. Right. It'll go back to the buyer. And this broker called and said, no, you forfeited that earnest money because your client failed to deliver the earnest money within 4 calendar days. Okay. So let's briefly touch on that. Okay.
Right.
This is how Utah law currently is written and how the contract works. So we have a 4 calendar day requirement to account for holidays, like 3-day holidays or 3-day weekends, I guess, that usually include a holiday, like the most recent one we had, Martin Luther King. And so the idea is that you have plenty of time to deliver the earnest money. So you basically have an 8-day window. You have 4 days for delivery, and then Utah laws, you have 4 days for deposit. Okay.
Now it's delivery to the brokerage.
To the brokerage. Now,
as written in the
Rep C. And the default language in the Rep C is that the earnest money goes to the brokerage.
Right.
For years and years and years, we've put earnest money typically at a title company, and you've had to have an addendum stating that the earnest money will be held at a title company.
Because you're changing the Rep C.
Yep. And it's the buyer and the seller that get to choose where the earnest money goes. It's not the agents.
Not the agents. They think so.
They think so, yeah. So in this particular scenario, our agent was a day late in delivering the earnest money. This is the part where I ate humble pie. I didn't realize that the earnest money was eventually delivered and deposited, but I did not know that it automatically triggered a scenario of default. And in my mind's eye, I thought, well, since we canceled the contract, there's no reason why we shouldn't get the earnest money back. But the broker on the other end said, no, you were in default. You can cancel. You have the legal right to cancel, but you're going to lose that earnest money.
Right.
And we ended up having a conference call with one of the attorneys at the Salt Lake Board of Realtors. And that's where I ate humble pie. The attorney said, yeah, Dave, this broker is right. And I remember telling both of them on the conference call, I said, even though it may be right, it doesn't seem ethical. It seems wrong that the sellers get to keep the earnest money just because we were a day late. We still have the right to cancel the contract. So you need to understand that you can be in default. Even though you have the right to cancel a contract, you could still lose your client's earnest money if they don't deliver it within 4 calendar days.
Right.
So that 4 calendar day time frame is really important. Okay. Now, there's a good ending to this story. I thought, well, I'm going to look at the contract and see if there's any loopholes. Well, we found out that the seller's disclosures deadline was only a few days into the contract, but before the due diligence deadline, where our agent had canceled, the contract. We looked at all those items. I think there's like items A through J or K in section 7 of the Rep C, which is seller's disclosures. One of those items was delivering CC&Rs. They had failed to deliver CC&Rs. So anyway, I went back to the broker and I said, we're not the only ones in default. You guys are also in default because you failed to complete that item. Okay, so the happy ending to that story is the broker didn't dispute it and we got the earnest money back. They came back and they were like, yep, you're absolutely right. Our seller was in default. So it was just they kind of canceled each other out.
That's a great counterclaim. There you go. That's what I'm talking about.
Yep.